Well, I will have to offer my apologies for a delay. Since the break was announced later, we have some changes in the schedule. Before we kick off our roundtable discussion, which I would like to hope will evoke great interest and you'll be interested to watch the discussion, I would like to say that many things which you will hear today will be improvised. We did not distribute roles and functions in this roundtable discussion. That's why I believe that the discussions may turn unexpected turns, evoking keen interest with our audience. But before we commence our discussion, I would like to introduce the panelists in this room, and I would like to acquaint you with those whose comments you'll hear today. We'll start with this side. First, what there is Patrick Ryan. Please, he is officer bearer from Google Incorporated. He responsible for open internet. He a political counselor in the Google company. On top of that, he is also a researcher. For a long time, he was teaching at various colleges, universities in the United States, and he's an expert in the area of development of internet. And he is responsible in the Google for developing a policy of that company relative to internet. Next is Vitaly Kalyatin, who is a known expert in Russia, one of the members of the working group for the development of modifications in the civil code of the Russian Federation, of the group which was responsible for intellectual property rights, and he contributed a lot to development of new version of alternations to the part 4 of civil code. On top of that, Vitaly is a practicing lawyer. For 10 years he worked in the Freshfields firm, and recently, for the last several years, he has been legal counsel in Rosnano. Samuel Green is a director of the Studies Research Center attached to the Russian School of Economics, which was founded about 20 years ago, and it provides training up to the master level, and this school has been recognized for this short period of time. It has become known as one of the few Russian-based international level schools with the faculty recognized and respected in the West, whose works are cited by many foreign channels and experts. I would like also to introduce Timothy Wu. Timothy teaches at the Columbia University. Prior to that engagement, he used to teach at Harvard as a visiting professor. He is a renowned expert in the United States on internet and new information technologies. To my right is Ivan Zasursky, who is the head of the chair of new media at the Moscow State University. On top of that, he promotes such a project as publication of private correspondent, which is a very rare channel working on the model of the Creative Commons, and one of the few people who are actively promoting licenses of Creative Commons in Russia, and he's a great proponent of respective changes to be made in part 4 of the Civil Code. Mikhail Yakushev, Vice President of the Mail.ru group of companies, a very well-known expert in his field for some time. He was with the government, was a civil servant, used to work in the Ministry of Communication, and knows has first information about internet issues, and he is developing electronic communications idea in Russia. One of the leaders of the Russian Federation of Electronic Communication, Alexander Domrachev, represents the Ministry of Communication of Russia. He has a long track record. At the beginning of the 90s, he worked in the federal agencies of the government communication agency, information, and was a lieutenant general there. But recently he worked in the Ministry of Communication, and he addresses the issues of internet. I would like to join Ekaterina Chukovskaya to join us, who is a Deputy Minister of Culture of the Russian Federation, also holds the position of the State's Secretary of State. This is the ministry which is responsible and executive branch for intellectual property rights, author rights, and she is the person who addressing this issue. She has been holding that position for 10 or 12 years. Prior to that, she worked in the Goskino committee. This is the panel which we will be talking to today. I hope that we'll have an interesting, engaging discussion. The views and comments may be conflicting. That is why I think it will be of utmost interest for us to listen to our panelists. You notice that the panel of our subject matter of our roundtable discussion is internet freedom or security. And we would like to discuss to what extent those notions can be counter-imposed. Is there a contradiction? Are we to choose between freedom or security? Or can those notions be somehow reconciled and married? I would like to address my first question to Samuel Green. This is a general question. Please tell us, Sam, whether internet is a danger, is a specific reality which should not be compared with the reality which we live in every day. Should we take it into account when we address the issue whether internet should be regulated, and what news, what new threats perhaps internet can present to us? Thank you. Thank you, Igor. And I would like to also thank all participants in this forum. I will commence by saying that I am a politologist, not a theoretician in this area. I am not a lawyer. I would do my best to start by offering my comments, and I will leave it to experts to conclude the remarks. The subject matter is a really complicated one, perhaps one of the most complicated to be discussed at this forum, and this is debated very actively by public in Russia, not only in Russia, but in Russia recently. That was the hot cake subject. This is actually the second conference for the last 2 days where the subject matter is part of the agenda. Next week there will be another conference. So that means that this is indeed a hot-heated subject matter discussion. The state institutions respect to protect our interests, citizens, and to protect our freedoms, and internet, to responding to the question, is no more dangerous, is yet another area, field of our social life. It is possible that there was a time when we could speak about internet as something, as a virtual world, which was of concern to a limited number of people within a society, a small sector of society, but that time is gone, both in Russia and in the West, long time ago, and internet is a part and parcel of the social fabric, is a key part of the social communications, of economic, political, public, and personal processes ongoing in the society. And this is a growing and actually prevailing number of people are engaged on a daily basis with internet. Thus, internet is a field where the state, the government, is supposed to be an active player. It is simply bound to be there because we, citizens, are there, because state, government exists for citizens. But this is a new field, and the physics of this new field are different from what we are acquainted with, from those areas into which the government is accustomed to respond. This has a structure which goes hand in hand to political demands of those actors who created that field without into majority involvement of the government per se, of the government institution. And that's why the structure simply cannot be violated without losses for all of the players, all of the users, parties involved in it. In Russia, we're discussing these days issues relating to protection of children in internet. We had a change of views yesterday, and we addressed the issue that there is a very neat balance has to be stricken there. All public organizations and governmental institutions and commercial actors in the field understand that if we restrict overly the creation of contact in the territory of the Russian Federation, or any other state for that matter, in any country, that part of the GDP which is related to the development of content will flow to beyond the boundaries of the particular jurisdiction. On the other hand, if we limit the access to the content in the territory of the Russian Federation or any other jurisdiction for that matter, we can expect that not only the 2 or 3 or 4% of GDP will flow beyond the boundaries, but much more substantial chunk of GDP will go, because the ability to access this content is a part of the personal strategy of lifestyle of those people who have already become the engines of the economy across the globe. And Russia, despite a great part which is played by natural resources in this country, is no exception from this rule, from these developments. And many participants of today are great clear manifestation, corroboration of this first statement. But still, to influence internet, to impact internet by the government filling the public demand, this is a bound duty of the government. There are two limitations which should be carried in mind. The first limitation is that if you speak about RUNET, Russian segment of internet, or any other national segment of internet, is inseparable from the worldwide internet. This is a banal, trivial statement, but we can understand that the internet is a trans-border phenomenon, and in any attempts to curb internet within limits of one country will only create irritants for people who work with internet on a daily, basis, using it for their business purposes, but will not likely to be effective in protecting the interests of citizens. The second item which should be borne in mind: internet should not be considered as a separate part of life of certain part of the society. If internet was created by a team of people, but now it has become a part and parcel of the social fabric. That means that to create laws which would operate in internet and that will be impact internet, but would be different from laws which operate in the actual life of the people, will not be a viable proposition and a feasible thing to do. So there are two issues which should be addressed here. The first, we should understand that internet is a mirror of social issues available in Russian or any other nation, but not the source of those issues. We should address the issues while not trying to fight their reflection in a mirror. What we see in internet tells us that those issues are a real part and parcel of the society, since the internet is a reflection of the society. But we should not address them purely in the internet field without taking regard of what is actually happening with people beyond the boundaries of them. Will be senseless and non-effective. On top of that, internet in Russia we have a strong, the internet needs a strong legal foundation. Perhaps it needs more regulation that so far we see it has, because those laws which so far have been adopted or discussed relative to internet, or they try to implement them, they try to apply notions which are inherent to other types of media, or piecemeal they are trying to regulate the internet, but quite often they use the so-called referral norms by deferring many functions of the internet regulations to ministries, executive branches, where these issues could not be properly addressed with the involvement of the public. And any parliament, I think this is the parliament where such discussions should be held, where is the greatest degree of transparency, and where the public and the political parties can be involved and participate and air their views and be part of the decision-making process. I would like to add in conclusion that the internet in Russia needs a strong, legal, solid foundation which would be defining the boundaries of the state authority in respect of internet, which would define what the government is allowed to do and what it must do and what it should not do and should not be allowed to do based on the provisions of the Constitution and the Convention of Europe and other international instruments of international law. And the interest of the citizens should also be taken into account first and foremost, as in any other countries, be it in Russia or any other nation. Thank you. Samuel, I have another question which I would like to address now to Ivan Zasursky, and I would be interested to know your opinion. I understood, Sam, to the extent that internet is an area where those things which are happening in our life are reflected. So that means that internet is not a recipe where we can kind and whatever we want, where we could escape from reality. Do you agree with such approach? What do you think of that? Thank you for the opportunity to offer my comment. There is a difference, of course. In our life, we have too much violence. In the internet, we have much less violence. The internet is difficult to organize direct physical violence, suppression. There are certain, say, things when say, schoolboys suppress their peer, but in order to arrange physical pressure to subjugate a person using internet means is not easy. So that's why we have a difference here. The difference is that in the real life, still we have many institutions which are based on the force and violence, and how this violence can be implemented, and the use of force is also regulated by the state. The state holds the monopoly on use of force, and also bandits and criminals. In the internet, still we have a different situation. In internet, we can communicate because the media is more horizontal, like more flat, like there are various mechanisms of group and psychological dynamics. There are very, say, nuanced and delicate mechanisms of self-organization, but it's a principally different media of non-violence, say, community. People can be loud, they can shout, they can air insults, but still we should understand that there is no place for physical violence in this area. This is one very interesting feature, because I think that now here in Russia we are witnessing the wild-scale campaign to propagate Russian children pornography. Over the last 10 or 5 years, I see that people have been trying to address this issue. I learned that such pornography exists. I never tried to search for such pornography, but now I hear from this child pornography from TV. This is actually a marketing, evil marketing. Understand what I have in mind. No one in the internet is not able to find child pornography without making an effort TV, one has to know how to search for that. Certain inclination should be. That's why I perplexed to see why the society while trying to allegedly address this issue, is actually marketing this issue. While this evil logic is in operation, why this project subject matter should be discussed widely and to pretend that it is indeed hindrance in our life. This is connected in my mind to a situation where we have our inner fears. Well, I speak as a part of the public person, chairman of the Internet Publishers Association, and in our country we do not have strong traditions of fighting for freedom. The value of freedom of speech, if we compare it, for example, with the United States society, where they used to say act against the colonial administration, and they developed and adopted the Bill of Rights. We have a different culture, historical culture, and the discourse is different in Russia as compared with the United States. In the Internet, the freedom of speech exists to a much greater degree. Our perception in Russia, we do not understand this as a value. We fail to appreciate it as a value, not to appreciate it as a value. We have to be more tolerant to those who use the freedom of speech, who speaks about their certain alienation to such persons. Then people tend to not to understand that the freedom of speech is a value. People tend to believe that the freedom of speech is good only when those people who speak agree, air the same view as they hold. So the situation as to how Internet presents our reality and our life is somewhat different. May I use this chance to have, make a few comments how these two fields are converging in the area of the legal regulations and in terms of the development of modifications, alterations for Part 4 of the Civil Code. Any amendments to Civil Code, nobody knows what those will be, is of great importance, not only because in the Civil Code issue of the free license will be addressed, I would like to hope so, and not only because the value of the public domain would also be enshrined in the Civil Code, and additional mechanism and levers will be put in place to transfer to the public domain automatically or semi-automatically some of the assets which are in the government area of jurisdiction. It is very important in my understanding to feel that the Russian leaders, being Mr. Medvedev, who came here, is making a stake on certain changes in the area of the copyrights in the world. And this is connected with such trauma, which reportedly the Russian leadership suffered when they suffered the pressure on the extension of the term of the duration of the protection of copyrights from 50 to 70 years. And the key instrument in this pressure was before the WTO accession. The key was the quota for steel. And that was a very strong pressure exerted by the United States, where the instrument was the reduction, curtailing of quotas for steel, and in order to gain, concessions from Russia in terms of the copyright protection term, they use these tools. Maybe it is contradictory to the values which I can see in the Internet right now, but one of the key value is easier access to information, to data, creating an opportunity for people to consume information, to create information, and to exchange information on the social network are now even more interesting. The data information is lands itself in the right texts and which created a very interesting and demanding challenge situation for mass media. I responding to your question not in a structured way. I apologize for that. I'm trying to address certain, keynotes which are of importance to me. But I do believe that those changes which are likely to occur in the civil code and other steps, new steps which will occur in Russia, will help us to consolidate this initiative and to promote this will to make new moves in the area of copyright worldwide, and will show at least what the Russian leaders have in mind when they appeal to reform this sphere. But I believe that many of the members of the audience would agree that any changes in the copyright protection are indeed ripe now, because the mechanisms of the copyright used to be put in place many, many years ago when they were regulating objects of material, tangible materials, and not information per se, not data per se. Thank you for your interesting contribution, and I welcome such improvisation. I'm not going to change the scenario of this discussion. Availing myself this opportunity, I would like to say that tomorrow we'll have a roundtable on patent law. We decided not to address the copyright per se in internet, because these issues are heatedly debated at various platforms. We wanted to address other aspects. But the patent law is something which is not often discussed. But Ivan addressed that issue, and I think that this can be applied to the patent law situation as well. And tomorrow, I think we'll have an interesting, engaging discussion as to what extent the rules for the Paris Conventions are in compliance with present-day economy. But I would like now to address my question to Ekaterina Chukovska, now that we are discussing copyright, and I believe that it's obvious that she should be the next person to speak. Ekaterina, I request you to take the floor, moreover so that you participated actively in preparation of those proposals which Mr. Medvedev articulated at the G20 meeting regarding the reforming of the international regulations of copyright relative to Internet. But we would like to hear your comments and your vision. Maybe you be able to expand on those issues. Thank you, Igor. I would definitely like to address the issue which Samuel started with, that indeed the intervention of the government in any process, including the internet, is of tremendous importance, and one cannot but recall the words of Ivan Ilyin: the state is not, the government does not exist to be to create paradise on earth. It exists to prevent existence of hell on earth, and I fully agree with that. Government is supposed to protect the weak. We should consider who are the weak. Children are the weak, the vulnerable part of our society. That's true. And on the 1st of September, when the new law on protection of children from harmful information will become operative, we'll see how it's going to operate. But at least such message, such effort is made, because children do need to be protected. And I participated in many discussions, and I know that the family is still a value. Parents are supposed to control what their children see, read, but government still has a role to control, to limit and to some flow of harmful information and prevent the access to harmful information which may harm their life in the future. Another vulnerable community are authors, and no matter how strange it may seem, any liberalization, renouncement of copyright towards curtailment of the terms, curtailment of the scope of authority will only lead to deprofessionalization of art, if you understand what I mean. I found a good maxima to share with you prior to our early speech. Gutenberg made everyone leaders, and the Xerox machine made everyone publishers. Well, Internet made all pirates, but now we see that Internet has made everyone authors. We can see that now almost each and every person using Internet, who is an active user of Internet, creates something which should be protected by copyright. And another bone of contention between myself and Ivan is the following. I am against the fact that the result of the creative activity should be labeled as information. If we look at the core of the Russian law in the area of culture, we see that on top of the creation works, we have information as well from the standpoint of the law, which the Minister of Communication appears. This is a document from the standpoint of the mandatory copy. I do not call to differentiate or segregate objects of the copyright, but let us look them still as the result of the creative effort of the author, not by the mere information which we can access and we can use legally or illegally, so I can gain certain information. This is not what we should be. And at one of the earlier information, Igor said that many times we address this issue, and Evgeny Vadimovich Sebastianov said that we can differentiate the creations to rational and emotional. Perhaps indeed this is something which the author desires. So, and I'm coming to the my favorite free license subject matter, and I think they may be more, less protected by the copyright, and emotional should be get the protection which they have now.
As for the free license, such proposals were made during the first reading of the Civil Code. It was made by the Russian Ministry of Culture, and it also wanted to take into account the tool we proposed to the Russian presidents to present at G20 summit. And now I was really surprised our current Prime Minister said that we had to keep working on this topic. I would like to agree that the author can refuse from his own or stay back from his own rights and copyrights. So in this case you don't need to go to a notary and notarize your contract. We can simplify the cooperation. We all propose that the information source for use of this copyrights in the internet, this source of information should be a single one. And now the Ministry of Justice was given by Ministry of Culture some amendments that can be also included into the amendments to the Civil Code, and these amendments describe this single source of information as an informational tool without any legal consequences. But in any case, we would like to try to do it. I think it can be useful. And even yesterday at Expercom, I heard a lot of opinions approving this idea of a single information source of the copyrights, and the proposal of the Russian Minister of Culture. This actually was concerning it. And thank you very much for your attention. Thank you. And now I would like to give our question to our international delegate, Mr. Timothy Wu, because we'll listen a lot to Russian participants, and now it's turn of our international guests to join the discussion. My question is, I would like to explain the context of this problem to Timothy. During the last years in Russia we have been discussing quite intensively, and Ivan is protecting this issue, that we need to provide the access to the information, to the knowledge. And know you deal a lot with the information problems with the new technologies. Why do we need an access to information and knowledge? It is needed in order to get new talented people able to produce innovations, to produce such a creative product. And internet is a very good opportunity for it. And now it is much easier to get an access to the information via internet. However, significant amount of information is protected by the copyright, and it also limits the users and access to such information. And Yekaterina said that it was needed to look more narrow to the information, because not everything what is protected by the copyright should be in a free access for non-commercial purposes. Certainly we should protect the authors because they created a certain subject. It would be not correct to provide a free access to what they did. But certainly some of the information can be free accessible, and Russia made its own proposals to G20 last year to enlarge the free access to information and knowledge in internet. And I would like to get familiar with your approach. What do you think how we should use the advantages of internet? Is it possible to take into account the fact that internet allows us to know more, to be able to do more? Can we also increase the free access to the information? How can we use the advantages of internet? Or can we also answer another question: what are the dangers in internet, because we get such a free access almost to any information?
There we go. Thank you very much for the question, and thank you for having me here. It's a terrific conference, and I'm very thankful to Igor for having me here. I didn't expect, you said this earlier, I didn't expect Russia to be so hot. I don't know why what's going on here. I thought we were north of almost the North Pole up here, and here it is steaming hot. So it's a very difficult question you've asked me, and I'll try and give some answers, but I don't think I'll be able to give a complete answer here. I think the hardest questions are ones in which both sides are right. In other words, when one truth faces another truth. One absolute truth, and I think it's hard to deny, is that the internet has been a great boon in many ways. You've stressed access to knowledge or information, and I think that's certainly true. If you're just very simple example, I don't know how many hours have been saved when you're lost and you have a phone that has a map and you can find out where you're going. I mean, this has just been an enormous boon to people who get lost a lot. It's a very simple example, but a clear example of where life has gotten better. And I also think, and this is particularly true in the United States, that the internet has been a very important engine of economic growth based on its serving as a platform for entrepreneurship, serving as a platform for innovation. Sometimes by talking about access to information, you can miss the main issue, or a very major issue, which is the internet is a platform for business that is unusual. Anyone who has an idea can try and reach millions and potentially billions of customers, and that's typically something that's very difficult. It's usually extremely difficult to reach customers. You need retail channels, you need all kinds of development before you can reach enough customers. And most of the most famous internet companies, Google is one example, eBay another example, you name it, probably Russian examples as well, started very small but were able to reach a lot of customers. And so this is very important. So that's one truth. The other truth, and I think this was put very clearly, is authors are very sympathetic. I'm an author myself. I've written 2 books, and everyone feels that authors can be very easily taken advantage of, and the copyright law in its most noble versions has been designed to help authors. That was the original purpose of it. So, that being said, there's no easy answer because there are 2 truths facing each other. I think that what is the most important thing is to understand that there is a trade-off and understand what the copyright law in particular in its protection of authors may also be doing, what other business it may be influencing or perhaps damaging. Because the problem with copyright is that even though the goal, I've said, is very noble, very beautiful goal to help authors, that goal can be used by existing industries that don't want to change their business models in an effort to defend their business models. Many of the changes in copyright over the last 20 years or so, I think, have very little to do with authors, very little to do with the protection of authors, and have a lot more to do with business models that are dying, that want to be protected. And I think, therefore, it's important to take the authorship claims as they lie, but not let it go too far. And so what I think has been very important for American copyright is that while American copyright is very strong, it has certain exemptions that are also extremely strong and have created important areas of innovation. And I don't want to have a long discussion of this, but I'm going to mention one or two. In the early 1980s, the Japanese company, actually in the 1970s, the Japanese company Sony invented a very interesting innovation, the VCR. Now you think of it as a DVD player or something like that, but it was a very important innovation in the 70s. And they were immediately sued as being violators of the copyright law. Case went to the Supreme Court, the American Supreme Court. And the ultimate result was that the VCR was allowed to exist. And a rule came out of that, the Sony rule, which says if you invent something that has a wide variety of uses but can also infringe copyright, you're not automatically liable for all infringements of copyright. And that rule has been extremely important and I think has protected an entire class of innovation over the last 30 years. There's so many American or international innovations that could not have happened without this fundamental rule that basically you can invent things, and if they happen to copy things but are not just made for copying, that they are allowed, they're not illegal devices. The second important rule is, I don't want to get too much into the law, but is the law of notice and takedown, which basically is a law on the internet which says, in the United States, that if there is illegal content being hosted by a company that is a hosting company or a search company, that you have to give them notice and then they have to take it down or else they're liable. In America it's called Section 512. And this law, I'll suggest, has been the Magna Carta. This law has been a fundamental law for the development of internet companies in the United States, among them Google, but you can name dozens of other companies, Twitter, Wikipedia, in some ways eBay, Amazon. All these companies have kind of grown in this little space not occupied by copyright. So what I'm saying is, yes, have a copyright law, and let it even be a strong copyright law if you want that, but make sure you leave the space where innovation can grow. And I want to say America, even though it overseas is always talking about strong copyright law, American copyright law has very important exceptions that have been very important to the growth of America's innovative industries. And I think sometimes the American message overseas is just strong copyright is the answer to all problems. But that message misses the fact that Americans ourselves don't protect copyright when it affects the innovative. We don't have the strongest copyright laws, actually, because we have these important exceptions. So that's my discussion. I'll have a last comment on this issue. There's some built into this question is who should make the decision. And usually your choices are between the Parliament or the courts. And I would suggest, and obviously every country is different, but to the extent possible, I tend to think courts do a much better job on these issues than parliaments. Parliaments tend to get very excited about stories they read about in the newspapers. The discussion tends to be highly exaggerated. A court has to look at an individual case and has to weigh the facts of that case as opposed to a general discussion about dangers to children or dangers to authors or dangers. The court has to actually look at what's going on here, decide an individual case. And I think the track record in the United States and other countries of courts is much better than of parliaments. Thank you.
Спасибо большое, Тимоти. Я хотел следующий вопрос адресовать Михаилу Якушеву.
Timothy, I just wanted to address the next question to Mikhail Yakushev, because we sat here a lot to the main topic of our discussion, because we're talking about the freedom and security, and it was an opinion expressed that the same regulation should exist in internet as in our real life. But there is another approach, that internet should accommodate more freedom. Timothy thinks that court can decide in every single case and can also provide a certain security to the users in internet. What do you think about it? Thank you very much, dear colleagues. I didn't like the title of our workshop we are working in, because the legal regime of internet, freedom or security. Because my experience in this area shows that in order to find a right legal regime of internet, we shouldn't deal with a contradiction between freedom and security. We just need to legitimize the freedom and provide the legal measures and needed level of security when using internet. Most of us are lawyers, and I would like to touch upon some pure legal issues. When we're talking about such things, we shouldn't forget about the legal system we are in, about the Russian Constitution, about the Russian nation obligations, about the imperative use Kogan's provisions, and we do have certain legal basics for internet. And we are talking about the additional opportunities to the internet are also based what is allowed to do here and what is not. A very clear example that you all know, the Russia's constitution bans the censure, and any measures that are aimed at limiting the distribution of certain information should take into account this constitutional principle. In this case, we should either update our constitution or should take into account this provision and offer only those measures that won't get anything censored. Because I would like to remind you the development of internet gave us a lot of new opportunities and also created new legal institutes, new legal subjects. Who could tell us 20 years ago what a site it was, and which lawyer can describe in Russia a site in legal terms? But we have millions, 100 millions of sites in the world, and they are actively strayed off. However, there is no single definition of this legal item. We also get a great number of legal subjects, and we also get absolutely new realities like social networks, and it also sets new legal questions for us. So we have a problem that the progress of technological progress is always ahead of legislation. And as I already said, we should talk about both things, about all things, but we should also understand very clearly what measures for freedom legalization should be taken, what we need to do through our parliament, to the international documents, legal documents. And I would like to not only to entertain you, but also show the size of the problem. It is a theoretical or also a practical question. Can a compilation of top secret information can be acknowledged as the breach of state secret? We know we already had some criminal cases upon this case, because in the internet the access to any information is much more possible than anywhere else. In one well-known social network, there is an opportunity. You can also indicate where you did your military service, and if you started with this all the data the users of the social network provide. You can also identify where the Russian army units are located since 1960 till now, and what weapons were used in these army units, and you can also look at the personal characteristics of a certain commander holders. Also, there are some other opportunities here, and this is a freedom that completely in compliance with the Russian legislation, but in some cases it can also create a certain damage. As for the security, we have here a lot of issues, and here we have to fight the cyber crimes, but it's only a part of a problem. Here we have a lot of questions and issues, but they are not well studied even theoretically. We also told a lot about the copyright, but we hope also to solve the problem with the anonymous users, because there are anonymous users using different resources in the internet, and it would be really good where a user can be anonymous and when the real identification is really needed. I'm not talking about the political grounds for it, I'm talking about the legal grounds, because sometimes we have a certain contractual situation in the internet, and I think it's a very practical issue. It can be really helpful, and if we really give up using this contribution one against the other, because the Russian legislation has a very good provision that the use of internet shouldn't be used as something would also oblige the user addition obligation towards the Russian legislation, and the use of the network shouldn't be used by the user to free himself for certain obligations. If, for example, it means if I use the internet, I do not have any jurisdiction. And in this connection, the copyright issues can be resolved much more efficiently, because there are commercial interests of the right holders, and there are also public interest to the information access, but it is right, but we can also turn it to a different side. We can also give more opportunities to the copyright holders, and they can also get new tools to sell their content and also receive money for what they created. And it also needed to provide guarantees how to implement these rights. And for the users, it is also important to get more opportunities to have legal opportunities to get access to information, and in this case the problem will be smoother and will be so acute as we seeing it now. As for the new questions, I would like to say that there are a lot of new questions, and for theoretical lawyers it's high time to look at the situation from a very new positions. Our international colleagues who are in charge for the regulation of internet, I'm talking about the refusing from the Westphalia system. In this case, the definition of the national sovereignty is getting not less clear than it was in the past, and some of the countries decided not to have any visa for traveling, and the Russian Federation decided also to create a custom union with the countries, and we also unify the custom provisions, and the internet gives the new colors to this situation. And the last thing, what is widely discussed in the last time, when regulating the internet, we have to take into account the new dimension, the stakeholderism, when all the multi-stakeholders, could be the government, business, some academic facilities, or users in internet, can work together a certain legal regime for. And I'm absolutely sure that if this contradiction of freedom and security will be taken off the agenda if it will be resolved. Mikhail just pointed out some topic that will be highlighted today, and I would like to introduce one more speaker. It is Viktor Naumov from the Silence Company. I already introduced everybody. Victor, it doesn't mean that I will give the floor to you right now. Victor is in charge of internet problems. Probably has been working with internet problems for the last 20 years, and he is probably one of the first people in Russia who started doing it professionally, and you were able to see his works even quite long ago, so he will also add a lot of interesting things to our discussion. And I would like to address my next question to Patrick Ryan from the Google company, and I would like to ask him two questions, but it doesn't mean that Patrick is not allowed to express his opinion to any other topics related to internet. The first question is, today we already talked whether it is needed or not needed to regulate the internet, and who should regulate the internet. Should be a self-regulation of those who are involved in the internet process, should be the government, should be an international organization. This is the first question. And the second one is, we talked a lot today that internet gives us a lot of new opportunities. Through the internet we get an access to a great amount of information. Mikhail said in his speech that information was a great power that could be used to real negative consequences and purposes. It was an example with the army units. This information can be a danger for the country, and the Google company should be here in charge, because your company is a hold of this knowledge, or can at least analyze it. Do you understand this responsibility? Because the only one who owns the information can rule the world. I don't want actually see the Google company, and like to say, do you see any danger from those who deliver the information to the users? Do you see any danger that this information can be used in the wrong way, so against the society?
Patrick Ryan, it's a pleasure to be here. I'm very happy to be part of this discussion and debate. I'm extremely pleased that this panel is indeed reflecting a number of different views on various different topics, and so it's a great opportunity to participate in this discussion. I'm going to get to your second question about the power of the internet and the influence that the companies like Google that aggregate information have in just 1 minute. What I wanted to talk about first is sort of the role. This is your first question, a little bit about the role of self-regulation and how do we strike a balance between individuals, self-regulatory environments, and the role of government. This picture up here is a photograph. On the left here is a photograph of my two little girls. I love this picture here because it really shows their personalities. The one in the back is Carolyn. She's 7 years old. The one in the front is Gabby. She's 5, and she's winning this race and is very happy. And Kara's in the back. She's very upset. So that's Kara's personality. She tends to be pensive and really think about things. Now, I want to tell just a little bit of a story here that I'll tie into the internet in just 1 second here. On the right, there's you can see a photograph that I took of a little note that Carolyn wrote. I came downstairs in December, and we have a little area in our home where mail comes in. This is regular old school, what we call snail mail, comes in and arrives, and another section where mail goes out. To my surprise, there was an envelope sealed with our return address in my daughter Carolyn's name in the upper left-hand corner, addressed to be sent to a credit card company, stamped, ready to go. The envelope was sealed, ready to be mailed, and this is apparently something that my daughter had put together to mail. And I'm thinking, oh my gosh, what is my daughter mailing at age 7? And so I had immediately this dilemma. As a father, you want to respect your daughter's privacy. And so I had this dilemma, do I really want to open this letter and violate her privacy? That dilemma lasted for about 1 second when I realized that my daughter was applying for a credit card. And so I tore the letter open and looked at it. And sure enough, on the back side of this paper, there was, of course, a credit card application pre-filled out with all of my daughter's information on it, ready to be sent to issue her a credit card. And on the back, this is what she wrote. She had this little note on the back of this letter that said, "Please don't send me a card. I am 7 years old." So I was very proud of my daughter. I folded it back up and sent it. And we had this conversation about credit cards. And she said, you know what, I've been getting a lot of mail lately, and it's kind of annoying, Dad. What can we do about it? And so we sat down and we mailed this letter back to the credit card agency. And we also wrote a little letter together to the Consumer Protection Agency as well, because we do have a responsibility as parents to meet halfway, to meet regulators halfway. There is a role for oversight in this world, but parents do also play a role. And I was pleased to hear Katerina also mention that in her comments, that this really is a two-way street. And part of that is the importance of not just government passing rules and regulations, but also helping to educate parents and to educate consumers of technology how best to protect themselves. Companies like mine, companies like Google, also play a role in that. Let me ask a question. Who here has been a victim of cybercrime of some sort? A phishing attack, identity theft, compromising email? If we could just get a raise of hands if anybody has been a victim of some way. Successful attempt, or it could be even an attempt. Even an attempt. That's a very good question. Okay, so let me ask you now a second question. How many of you have called the police? Right? So, well, good. So we have one person. So the reality is, and that's a very typical sort of response when I ask this question in public settings. People think of cybercrime as something that's just totally new and different, and yet it's an attack. It may not be a violent attack, but it is an attack against people, and there is a responsibility that the police and authorities have in enforcing those rules. And one of the missions here of this particular forum that's been discussed is the importance to modernize the law to take into account the modern world. And I would suggest that just as important, and perhaps even more important in the internet world, is to help educate and modernize the understanding of how the internet works, so that enforcers, so that police, and so that those of us that are involved as users can leverage existing laws in the internet world. And I think child safety is one of those contexts. So let me see if I can go to the next slide here. If I could have some help with the next slide, I'm not sure if well, the next slide, if it does come up, is a picture of the Titanic. There it is. Thank you. And I also, like Mikhail, had some difficulty with the title of this particular panel, Freedom versus Security, because it presents two things. It's either freedom or security, or at least that's the impression that I have. And yet that's something that we've been struggling with as a society for a very long time. And this was the case about 100 years ago when the Titanic sank. And there's a technology regulation story here that I want to tell as well. About 100 years ago, the Titanic hit an iceberg. And tragically, it wasn't the iceberg that ensured the death of about 1,500 people. A lot of it, as it turns out, after hearings that took place bilaterally between the United Kingdom and the United States, it turns out that a lot more could have been rescued had a ship that was only 10 miles away had the appropriate radio signals on, if there were certain regulations in place to ensure the communications. And there are a lot of theories as to why that happened. But a lot of people believe that better regulations would have ensured the safety of many of the people that sank in the Titanic. And this was a turning point in many ways in the wireless industry. There were hearings that took place in the United Kingdom and in the United States, and then ultimately at a group that has become the International Telecommunication Union, which is part of the United Nations, and it was decided to regulate wireless spectrum in a new way. And there was in many ways what we call a spectrum lockdown. And certain rules were passed to mandate that ships have certain technology, that ships are able to communicate with each other in a more certain way. In the short term, this was a really good thing. Something really needed to be done. There was clearly a lot of deaths here at the Titanic, and a lot of lives could have been saved, and that was a good thing. But in hindsight, it's very clear now that in the name of security, certain things were solved, but various other problems were created. Since that moment, wireless spectrum has essentially been locked down. And through these regulations that are part of the United Nations, through this group called the International Telecommunication Union, and then rolled out into different national regulatory authorities, policies for wireless spectrum have essentially been frozen in time. There have been changes, and there have been mobile expansion so that we can use mobile phones and use things like Wi-Fi, and so things have adapted slowly over time. But we will never know how things might have looked had there been more of a free market, had there been more of an opportunity for wireless spectrum to develop and for the market to let it prosper. Now fast forward to 100 years, right? 100 years later, the Titanic sank in April 1912. Here we are in May 2012, and the internet is really just this incredible phenomenon. And particularly in its speed and the pace of innovation. For this, credit isn't due just to the engineers and the entrepreneurs that make the breakthroughs, but also to those who have helped to steer the ship and create an environment in which the internet could thrive. Unfortunately, this is now under threat because there is a treaty conference that's taking place this year at the United Nations to step in to regulate the internet at an international level. And it's a very attractive concept in many ways because the telephony has been regulated through these international treaties for more than 100 years. It's a system that everybody knows. But as Samuel and Mikhail have both mentioned, the internet is not the telephone system. It's developed through what we call a multi-stakeholder system, a group that looks very similar to the makeup of this panel, representing business interests, government interests, civil society, and academia. I don't think we have any engineers on the panel. But if we did, this panel would represent the type of multi-stakeholder system that in many ways represents the governance of the internet. Now, let's face it, there is a perception that is not entirely wrong in the international community that the internet is controlled by American interests, right? And we, as a community, need to do quite a bit in order to change that perception, but in order to change that reality. Many places like Russia, as well as other voices around the world, and particularly in the South, that are incredibly dependent on the internet, want to have more voice in how the internet is governed and how the internet works. I believe that the best place to do that is through reform of the existing multi-stakeholder systems. By looking at ICANN, looking at IETF, other groups that are currently developing the standards and working on that, rather than moving that into an organization like the United Nations, which is a wonderful place for peacekeeping, but it's not a place that is known for multi-stakeholderism, for the participation of many different people in the internet ecosystem that have come to develop it as far as it's come. So I have one last slide. It's not that important to have the image on this last slide, and this sort of gets to the question of contents. And I think this is going to address some of your question about sort of our role as a steward of some of that information. At Google alone, there are 60 hours of videos on YouTube that are uploaded every minute. So, if my math is correct, in the 2 hours that this panel will take place, there will be 7,200 hours of video on YouTube, which is 300 days of content. That's a lot of information. And there are different ways to sort of control that information. There are copyright concerns. There are issues of posting things that are just inappropriate. And in a global world, there are a lot of different cultural sort of views about what's right and what's wrong. Governments are always struggling with how best to control that and how best to influence that. And I would suggest that one of the wonderful things about the internet is the ability for users who are really interested in participating in the regulation to be part of that policing structure. On YouTube, there's a community that helps flag video content and often alerts the company, alerts us, and alerts even authorities about bad content far before the government itself could find it. And so it's really important to have this cooperation with the community in order to police the internet, because it is something that's so big and so large that no single entity could control it. Now, everybody here has heard of SOPA and PIPA, the big fight in the United States. It was an American rule that was proposed in legislation that would have shut down so-called rogue websites. And that law was shut down in the United States. One of the reasons that SOPA and PIPA was shut down is because of the netizen community. People who use the internet and enjoy the internet and love it so much are really have trouble when they believe that rules are being made in a dark, smoke-filled room. And to some extent, that's the impression of what happened with SOPA and PIPA. And we're seeing now with ACTA, a similar treaty that's now starting to fail in the international context, mostly because of the perception by internet users that these rules were made in a sort of a dark, smoke-filled room that did not have their participation. So it's very important in an innovative environment to keep that in mind. And so I'll conclude, and I think that I can address your third question about our responsibility. The first point that I think is important for us to keep in mind is that we need to pass new laws. The internet is different, and there is a place for new laws to be passed. But before we go out and pass new laws, one of the most important things for innovation, again, is to recognize that there are a lot of existing laws that can be applied in the internet context, and training and familiarization of how to adapt those laws to the context is a really important thing. The centralized regulation of the internet is something that that's being proposed right now in this treaty conference that I mentioned, and it's something that is attractive to many governments. But it's also really important in an innovative economic environment to let the internet flourish. It's still growing. In most developed countries, the internet represents 3.4% of GDP, which is larger than the energy sector. It's larger than agriculture in most countries. In Russia, right now, the internet represents 1.9% of GDP, but it's on a path to grow to almost 5% by 2015. And part of that reason is because of the innovative environment that still exists here and that exists in many parts of the world, and we should consider to continue to let that grow. And so I'll address your last question last, and then we'll move on to other speakers. The role of a lot of people think of Google as the internet, and while I find that flattering, yes, a lot of people think of Facebook as the internet as well, but the search function of Google is really just a reflection of the internet. There is no, Google will make a copy of the internet pages in order to be able to help people find what's on the actual internet, but Google itself is not the internet. And so it's important in this context to keep in mind that, again, when we talk about responsibility and content and where things are and how they're stored, that the millions and billions of websites that are out there in the world is where all that information is stored. Now, us and other search engines are in the business of reflecting that content, just like a mirror does. But controlling the intermediary, controlling a company like Google or a search engine like Google, can only have a limited effect there, because there will always be routing arounds, because Google has no relationship with the billions of websites that are out there in the world, and we can't take them down. They'll still be there. Even if Google were to go away, that information would still be out there, and entrepreneurial companies would find other ways in order to be able to serve that up to other citizens. So we certainly have a responsibility in that regard, and it's something that we do take very seriously.
Спасибо большое.
Thank you very much indeed, Patrick. And now I would like to address my question to Alexey Domrachев for a very simple reason, because here in Russia, presently the Ministry of Communications, they are very actively involved in developing Web 3.0 platform, which provides for development of international rules at the national level addressing Internet. But to the best of my understanding, this is still not a governmental interference in Internet to the extent that Patrick referred to. This is done for a different set of reasons. But why should I steal the steam from your, say, engine? Thank you, Igor, for giving me the chance to offer my comments. But addressing the Web 3.0 issue, I would like to come back to the first issue on Internet and what is Internet is all about. Is it a new reality, or is it a slightly modified actual reality, reality? I tend to hold the second point of view. I believe that Internet does change our life, but not dramatically. Mr. Ryan quoted certain, says, images to sustain his point of view. Let us imagine that a set of people lives in an ecologically pure house where there are no elevators, no electric power supply, or other modern devices, no mechanism. And this group of people relocate themselves to a skyscraper where they have skys with elevator and the full set of modern amenities of the modern civilization. Clearly now the key rules of living will retain with that group, but new technological nuances will develop. The rule to how to use a speedy lift from a standpoint of safe use of elevator, and a number of other peculiarities which issue or stem from technology available in the skyscraper. In St. Petersburg, there are authors, Nikolai and Juraltov, who are professionals in registration of real estate. They each published a book in 2006 in which they offered the results of their research on the registration of real estate. And the first effect of registration of real estate was described in the Bible, in the Old Testament, according to a certain procedure, technology. Well, a certain person registered a plot of land near a mountain. There was a procedure described in the Old Testament. Further on, those authors say that Egypt, Greece also used some technologies to register, say, the land as a property. They had some stones, they have some papyri. Now we have internet technology, and to a certain extent many such state services or functions, and we're creating electronic government. We can use internet to get property registered, but whether it is possible to get all the services from that range of set of services or not, I do not think so. Can we register a piece of real estate which I bought in Spain remotely? No, it is not possible. Or another sample. For example, my colleague fell ill who worked in the State Duma. So it was suggested to be diagnosed in a clinic in Israel. She asked the question, what responsibility of Israeli, to what extent Israeli doctors will be responsible for remote diagnostics? And she asked, and they said, no, we would not be responsible, we would not be held responsible. So who would win from that situation? And she refused, actually. The doctors could say benefit somewhat from this exercise, or my colleague who did not receive maybe a very interesting doctor consultation. I think it was a lose-lose situation, because presently we do not have a modern internet services which would be able to say transborderly get across responsibility, and we think that it is possible to set up such a service, and we called it Web 3.0, and we discussed today a lot about the regulations of negative phenomena in internet, like child pornography, copyright violation, etc. I believe that regulations can be a creative activity. We can create services which could be trusted, which people are accustomed to use in their everyday life. And it is an urban situation when medicine would be without medical books or reference books, or examinations could be held without examination records. But now, when the Internet provides remote services, it is necessary to create such infrastructure for such remote services as well. I spoke with my British colleagues and we discussed the issue about electron auctions in Europe. Well, I asked them, do you have, in Germany you have state tenders. Can you, participate in this auction remotely from UK? No, we cannot. We take hard copies and go to Germany, to Berlin. The same question I asked to our Czech colleagues and the Slovaks. There used to be one country and they cannot participate in such situations, in absurd situations. Internet provides a wide, very liberty, non-authorized area of media. There are negative segments of Internet which we have already referred to today, but there are no trusted positive segment in Internet or segments in Internet where we can make information transactions safely and securely at the time that we are accustomed to make in our real physical world. And this is a task, this is a challenge that we are trying to address using the ideology of philosophy of Web 3.0. We understand that Google, of course, is the author of Web 2.0, technology, and we learned that our initiative Web 3.0 was of interest for Google. And now that we're talking about the constructive, positive side, now I would like, following the round discussion, to talk to my colleagues with Skolkovo and Google, because our minister is awaiting at the the Google reaction to such audacious Russian initiatives. I would like to comment on the Web 3.0 initiative. Certain teams already have tried to use such a label. It is not irresponsible. It is not necessary for us to stick to this particular, number. The Internet can develop. This is most important for us. In one area towards another direction, it is important that new services, constructive services, should appear. We can change the label with maybe 3.0, 3.14, or whatever, and there should be a broadcasting, exchange of information, and these are the principles of interaction, of communications, which Russia proposed at a variety of international fora, including the United Nations Organization, those forums which Ryan referred to, CFACTA and Central, a third working group of UNCITRAL, the regulations of disputes online, the issues of identification also are touched, which Michael actually referred to. The fourth working group relating to with e-commerce, and the same issues are discussed. They understood that it is indeed a very topical set of questions for a variety of international organizations, and we became audacious enough to offer our own view and a solution, and we want that Google should stand up and criticize us, so that we should improve our position. Perhaps we can do business together. Yes, I would definitely like to give the floor to Timothy, and I think when I should give the floor to Timothy, but I am representing Skolkovo, but Alexei has already mentioned that, and now as advertiser, I can say that, well, we could not have held this round table without the support of Skolkovo, Foundation Skolkovo. If anyone is interested about the Skolkovo Foundation, I call upon you to visit our site to understand where we are at, how far we progressed in the creation of innovative discussion. I would definitely welcome you to come and speak to me. Timothy wanted to offer a comment. Yes, I understand. That is this.
I wanted to ask Alexei a question about Web 3.0, because I'm not sure I understand it, the concept. Is the idea to change the Internet, or is the idea to offer an alternative web? In other words, is Web 3.0 become the only choice, or does the user have a choice between the usual web and Web 3.0?
For us, the answer is very evident. Web 3.0 is not a new quality of the entire Internet community. It's a process of formation through international regulations and self-regulation of a certain combination of new services, of such services which are traditional for people who are accustomed to get in the real physical world. Let me cite a couple of examples. Back way in 1961, in the Hague, they adopted the Hague Convention on apostille, legalization of documents, paperback documents through apostille. Such a normative act for electronic documents is nowhere to be seen presently, since citizens cannot exchange electronic apostille documents across the borders. They have to resort to old paperback services, which is an inadmissible anachronism and a costly in the situation of financial crisis. Too costly to go personally to send papers. We have to cut costs, and these additional services should be created. This in no way would not mean that it's necessary. We should not regulate the entire Internet and marshal it across rigid rules. No, this is not the case. How often we make legally important transactions? Once a year, twice a year, 4 times a year. How many information transactions we make every day in a year? Millions. And the same occurs in the net. The million information transaction citizens can get from the regular network, and a certain limited number of legally important, secured, insured, acceptable in court as evidence could be done via a new section of Internet. So these services should be created, offered for them in an electronic media. That's something which I would like to develop.
Well, thank you for the answer to my question. And I guess my only comment on the Web 3.0 proposal is I would say wish you luck, but I think that I would also point out that you are trying to invent something which in some ways exists in some forms, and something which private industry, I think, is trying very hard to invent also. So, for example, if you think about the banking industry, the banking industry has a very strong need for secure transactions. You can't have people just logging into banks, and you don't want the need for security when it comes to banking is very obvious. And if you look at banking websites on Web 2.0, they're quite secure. They have all kinds of features designed to make sure that it's actually you who is using the bank. And I don't know the development of these other places, but they have certainly been enormous levels of development in things like banking software. So I just want to suggest that there are a lot of secure transactions that happen on the Internet. Right now I'm buying a house, and I would say that most of it I'm doing using Web 2.0. So that's one point. I think another point is that some of what you're interested in, which is non-anonymous communications, is also being developed by other companies. Facebook is a good example. Facebook, the principle of Facebook, founding principles, it's supposed to be real people. And so when you transact with people on Facebook, supposedly you're transacting with someone who's real. And sometimes there are fake people, but generally speaking, if your brother or sister or your friend is on Facebook, it's really them. And so Facebook is also in some ways trying to do Web 3.0. You can understand it that way. So I want to say you've obviously hit on a very important concept, because there's so many private companies trying to do the same thing. And Facebook, which is about to IPO for a huge amount of money, is in some ways taking advantage of the principles that you mentioned. So I think I need to commend you for coming up with such a good idea, but also it's important to understand how many private efforts are going in that same direction.
Вы знаете, я вот когда...
You know, when I was introduced, I was working in a federal communications service, and I made a significant corporate network for the central bank after these well-known Chechenian bonds. As it was the first legally important network or systems in the Russian Federation. Now we have a great number of this corporate system here in Russia. As for the cross-border systems in the world, I do know 2 of them in the world. This is a SWIFT system, you already mentioned, and in other words, the passport visa system of a new generation that was created under ICAO after the 9/11/2001. It's a corporate system. Certainly there is a company's head that can also resolve all the inter-corporate conflicts. And the head of the Russian Central Bank, Mr. Gerashchenko, was able to resolve all the conflicts within the central banks, but the common citizens were not the participants of this system. Also, the citizens cannot take part in the SWIFT or the PVNP. Only policemen can take part in it. Probably there is no task to create such an open system for all the citizens in the world. It could have the same meaning as the corporate system have. And the Web 3.0 is aimed at solving this problem, and some of the corporations were trying to resolve this issue privately, and these systems already exist, but there is no interoperability between these systems. But this service can be demanded and used by all the people in the world, and the people can use all these services one by one. So in this case we should get the access cards for each of the system. Why shouldn't people have a single card that can be used for all the transactions in the internet? You can make bank transactions, you can also make transactions on the stock exchange market, and you can do everything what common people do now via paper, because the paper document is scalable, interoperable and unified. For electronic work flow and paper flow exist only in corporations, and that's actually what I was talking about. And the citizens cannot get the services that used to exist traditionally from in the past, and it is quite a acute task now. And I would also like to cooperate with the colleagues. We can also provide our materials. There's more than 100 pages in order you have a look professionally and criticize us. Certainly we can do it within the Skolkovo Foundation, because it's probably the most innovative organization in Russia. It is not an advertisement. I would like to ask a short question. Are you afraid that if such a system can be broken, if WikiLeaks or a similar system can get information about everything? Certainly I'm afraid of it, but every system can be broken, because there is no 100% locked or closed system, that resilient reliable system. Certainly I think these dangers can move us to take new decisions, to create something what can be innovative. In this case we need this Web 3.0. It is quite expensive to use papers. It is also quite expensive to go to Israel and anywhere in the world in order to get a good medical care. And I'm talking that we will get needed a service, medical services that can also be, and you can also get some proof that you get some medical service, and you can use them in court if needed. I think it is a very wide field for discussion, but let's go back to what we were discussing, and especially in the what the Patrick and Alexei were discussing. Do we need a certain regulation, national or over-national regulation? I would like to address this question to Vitaly Kalyatin. I want you to share your opinion here. I would like to agree with Mikhail, because I think shouldn't be any contradiction between the security and freedom. When we talk about Internet and the legislative role here, I can rephrase the old Roman quotation of law. Law is a science of compromise, which means if you formulate or stipulate a certain legal provision, you have to take into account the interests of different levels and create such a model that can also let the different people act together with the minimum conflicts. And every functioning system has its own law, because law regulates every system. So we shouldn't get involved in a certain system and let the system get self-regulated. It means the system will also fall down and won't be able to operate. In this case, I can make several conclusions. First, when we're talking about legal regulation for the Internet, it's a compromise regulation. You have to take into account that it's quite a complicated system, taking into account different interest factors and so on. And where simple solutions are proposed, if you have such a problem in the Internet, let's do something, let's ban or allow something. I think it's initially a non-correct decision, because we took just one single element from the whole system. And the second thing, what is absolutely ignored by the Internet society, because law is not a danger but a guarantee for security and freedom. If there is a law, it's a moment when a certain subject is quite strong, can limit himself in his interest. If we say that there is a certain issue shouldn't be limited by law, it means a certain strong person doesn't want to limit himself in certain interests. So law is intending to protect a weaker person. How can we see it in Internet? We have told, for example, we shouldn't get involved in a certain process, because certain process can be self-regulated among the Internet users. What is the result of it? The agreement loses its character, because the more economically stronger subject can have a more stronger influence on another user. In this case, an agreement, instead of a tool for free solution, is a tool of dictation. In this case, we need a legal regulation here that will also eliminate the influence of a strong party. For example, everybody knows the following example. If you install a certain software on your PC and you get a license agreement on your screen, and you can also agree or disagree with this agreement, and this agreement contains a lot of provision how you can use this software. However, the following moment is ignored, that the current legislation allows us to use the software without license agreement, because our civil code of Russia allows every individual to use the software as a user, just as a single user version. So the user doesn't need this license agreement if the user acts really good. Law is here as a guarantee for the interest of a certain user that is not able to protect his own interests. The same deals with the national or cross-national conflicts. If we don't have any international law provisions, and national legislation can not always protect its individuals, and because there will be always a stronger party or a certain party having certain preferences, and this party will make some conjectures on a certain issue, only creating some general steps, and can also make the web working in general. And the third moment, when we are offered simple solutions in internet, we should understand that a law is a tool that can be used by different parties for different purposes. And one of the solutions which is proposed is to introduce the registration for your works, and if your work is not registered, it can be used by anyone on the internet free of charge. And how it can be accepted? First, it is very good that the internet user can use the results for intellectual activity, because there is a limited list, because everything what is out of this register can be used. The second model is because this tool can be used for the restructuring the market, because the first law on copyright in England was in the 18th century. It was created because there was a fight between two publishing houses in England, and one publishing house was protecting the concept that my right is like a property right, and if I purchase something from the author, it should be mine forever. And another publishing house was protecting the position that the copyright was limited by time, and then the other publishing houses were able to use this the right to publish a book. And when we are talking about the registration, it means that we can say that certain individual and author can have rights for a certain work. Now I'm talking about the monopoly for to control the information resource. Why this monopoly can be better than another one? It is subject to discuss. And the third, this idea is not really new. I've just got the UNESCO bulletin for the copyright dated 1999, and the head of the Copyright Office from United States, Mr. Ralph Oman, writes his opinion about the registration of items in Internet. And his purpose is that in this case we will stop using the anonymity in the Internet. We can track what an Internet user do with a certain work but purchased in the Internet. And we can also track everything what is happening in it, and those who are against it will be punished. Fine, if a certain provider decides to get a user because he refuses to track the information in the net, it can be against our interest as the interest of the right holders. When we look at these simple solutions offered, we should understand it can be supported by different purposes, and if someone says let's register everything, that in this case we give a freedom print in internet, probably there is a certain party protecting its own interest. It doesn't mean that we shouldn't take this decision, but if such a solution is proposed, and if we would like to embed it into a law, it shouldn't lead to a monopoly or to a certain misuse. If we give a right to a certain person, we should also grant limitations to the society of free use. When there was quite a long process about the amendments to the Russian Civil Code, those discussions about free licenses, about the responsibility and liability of providers, these were issues about the limitations that we need to identify, because if we identify a certain provision, it can be used to absolutely different purposes than it was planned in the beginning. And all the interested parties were taking part in this discussion. We can also hope that they also know when this certain legal provision can act to the favor of a certain strong party. I would like to tell you that the law is a guarantee for freedom and security, but freedom and security can exist only when we understand that we need probably congest our own interests in order to accept the interest of any other person. And if the countries manage to agree on this common approach in this issue, we can say that the system will work efficiently, but we are only in the beginning of this way. And the national legislation, we get some legal provisions. On the international level, we do get some proposals like the Berne Convention or something else. In order to create an efficient model, we need to go quite a long way, but I would like you not to resolve it with very simple means, because they can create additional problems. We should really keep it in mind. Thank you very much. And now I would like to come over to the last speaker of today. Then the delegates can also ask the questions, and the speakers will answer them. I don't want to address any special question to Victor. Victor, you probably heard almost everything in our discussion. Probably you got some ideas in your mind, and what do you want to comment anything what hasn't been highlighted yet? I just want to change my microphone. Dear colleagues, it was very interesting for me to listen to this opinion exchange, and the ideas expressed by my colleagues were quite important, and I would like to share my information, my knowledge I collected. I apologize for being late today, and today I had two cases at the Commercial Court of St. Petersburg. These were cases against a well-known internet site. In one case, the internet site won the case, and in the second case, actually the court decided that there was a certain breach by this site because a certain illegal content was uploaded to this system. If we will look at the prospects of the Constitution, a well-known search machine won a case in a court in Moscow when a publishing house wanted to sue the search machine because some information was stored in the cache of the search machine. Then in Moscow there was quite a well-known internet site which was a video service that lost its case in two court instances because the court said that you didn't brought a certain user to the court and it was not able to identify it, so you as internet site are the only party who is in charge of breaching the legislation. So it's a very interesting period of time because the law is inertial and the internet and our society are developing very fast. So due to this difference we get a lot of economic and legal problems, so there is a certain challenge for the law and for the international governance. I think this challenge is not fatal, and the government, the courts, and the business and society are not able to cope with it. But the decisions that can be acknowledged and accepted by the international society and by the countries doesn't exist, and we understand that to be anonymous in the internet. It is quite comfortable for users, but in legal terms it is a problem to identify the user. It also complicates the situation with the right protection. We have international information space in the internet. We also use the e-commerce in the internet, and there are no international agreements here, and there is no jurisdiction for in case of disputes, because some international companies already had cases in the Russian commercial case, and there are some Russian companies having disputes in American courts, because this unclarity is a danger for the business. Another problem which is very popular for the Russian internet disputes, these are the limits of the information providers, how the providers should be liable for the user's activity when certain services in the net are offered, because a user cannot get access to it. User needs an internet or hosting provider over a social network or another quite complicated service. In some cases, user can get information, or in other situations, the user can create the content or can upload the content to internet and can do it legally or illegally. It can also enlarge this list of challenges, because there is a well-known problem that is being in a theoretical area now, because when the searching robots existing in the internet or any other solutions, they are acting within the educating algorithms, because these robots will start act more intensive. For example, the robots can be started now to clean an illegal content. Who will be in charge of this, of the activity of this actually independent items? They just identified something in the internet and started to eliminate it, and even the creator of certain software who cannot be aware of what is happening. Probably it's a kind of science fiction, but this could be a reality in the near future, because we are really behind, especially in the legal area. We need international legislation here, but we have to understand, if we get a single information space, the countries and have different culture, different interests, different legal practice, different understanding of freedom, and I think we shouldn't expect that we will sign international agreement for these problems in the near future. So there are two ways: either self-regulation or the development of national legislation. The self-regulation, it is not easy, because the operators and the users can solve some problems, but they solve these problems and these tasks actually quite privately, but they cannot resolve them globally. Even in the Russian Federation, when the reality and the self-regulating culture is not at the same level, so there are some very successful solutions of 1999, when the telecommunication operators invented an interesting solution that they also incorporated some in the services. As the development of the national legislation, there is also interesting situation, because different countries made different experience in this area. We have a very interesting, very deep legislation in the United States, very interesting court practice in Europe, less experience in Europe. We also have some other countries in the world which also incorporate the Russian Federation, and we should also take into account the specific aspects of these legal relations, because I have been known with Vitaly for a long time, and Vitaly was one of the authors of the part 4, for example, the article about the reliability of the information provider and the mediator, because here we use the international experience, because a certain platform is a technical function, then we have a sensor, so the sensor doesn't exist in many countries of the world, and the sensor start works when the provider was informed about a certain breach of law. There are more complicated models when the users can also object to a certain extent, and then the provider can also let the parties sue each other in the court. But in the Russian Federation, there is a need to work out this legislation about intellectual property. But I certainly like the intellectual property, but for example, if we talk about the commercial secrets to the information relationships, and these information relationships will state in this, it needs to be regulated. We have a lot of issues that are not resolved now, and they can also deal with information space. We need to identify the owners of the information resources and system. When someone distributes a certain content, we need to know who is doing it. If someone reads it, we need to follow and track the user. But if someone provides certain information to unlimited circle of people, we need to implement it, and the owners of the service systems should, in the Russian Federation, similar to the privacy of children in the United States, should be limited in rights. So you either have a right to have a look at a certain content, or you have a right to publish a certain content. This is actually the combination of regulation and self-regulation. In this case, you can make a choice, and if you make a choice, you can have to follow the rules. As the disclosure and information about the user, it is quite an interesting situation. We have also legislation about the personalized data. We have also constitutional provision, but not only information that is circulating in it is the personal data. So we need to be a transparent system that can identify in detail for the platforms and also for the police and courts and different stages, also at the stage of investigation, to what extent it should also be the maximum participation, of course, who should provide, what information should provide to whom. Because in this case, the information achieved in different countries on different legal basics, or sometimes on the political possibilities, can also do harm, because this openness of this space without their privacy can also do harm to the users who really trust to this anonymous use. So also some problems of the internet regulation, for example, with the electronic workflow. We also have got a new law about the electronic signature and digital signature. We also have some good ideas in our legislation for the electronic contracts, and these are some milestones that can also create a very new environment for the existence. And it is not a top secret that it is more complicated to protect the interests and rights than in real life. And it is certainly the task of the legal society. Because also it's quite difficult also to protect our rights in our life, because the difference between the virtual reality and our common reality is quite a difficult way, because there are a lot of different interests from the government, from business, from international business, from different individuals. Here we have to resolve very complicated tasks, but they are very interesting. Thank you very much.
Okay, let us give him, I think there will be some questions still, and then we'll give him a big hand. Thank you. Okay. Please use the microphone so that interpreters can pick up what you're going to say. Thank you. Well, to Viktor Borisovich, can you tell us how a jurisdiction issue is addressed when there are certain cases when the site is in Moscow, site is registered to the company in the Isle of Man, and the server is somewhere in the Caribbean. So it's a real situation. Who will be under what law will be applied for placement of the information on this site? And this situation, what answer you will give me? But generally, whatever your answer will be, is there any sense of a national jurisdiction, specific and not specific? Because in any case there would be certain offshore virtual territory, and depending on what legislation will be applied, and the address would be registered in that virtual offshore territory. Second question to you said about the unified electronic signature registration across the world. Perhaps we should address Russian issues first, and then we'll address the worldwide issues. Now a legal entity to file financial reports in electronic form shall have one signature, and they have, which they pay for. In order to understand that tenders have another electronic signature, which also applies. If a person wants to participate in electronic form, he has to register himself differently with various things. So we cannot create in Russia a single electronic signature. We have a variety of industries for that. Thank you, Pavel. Thank you, Pavel, for your question. It can take a long time and speak at length from a standpoint of theory. Indeed, objectively, it is best to have unified regulation, but this is unattainable ideal because all countries have their own, all Jews have their own laws and rules of application of law. And now we're presently at the end of the short race. Well, we are at the position of freeze, and we cannot say request others to wait, others to come. But without national regulations, we cannot do. We can adopt regional documents at the CIS level, though it is not going to be like. But your problem of jurisdiction, indeed, in various situations, we can offer various solutions. The simplest solution in terms of the place of location of the registration of the person who disseminate the information. But this approach is not best in all cases. In our arbitration code, there is a norm saying that issue can be, subject to court when damage is made on the territory of the Russian Federation. The situation arises when the Russian courts have cases when respondents are Russian non-resident. There are other cases in terms of the consumer laws within the EU laws providing opportunity for a consumer to litigate in other jurisdictions. So coming back to general issues, there is no progress. There won't be any progress in this area until states come to terms in this respect, and the states will not come soon to terms. So in this case, considering this, every nation will take such decisions which is most comfortable for individual nations. This is the sad state of affairs. You know, you have asked a very, very good question. It's you hit the bullseye, as they say. In order to respond that, I will have to recall the history of development of this idea, Web 3.0 and transborder transactions. It happened so that I was busy with electronic government issue in 3 organizations, in FABC, in the State Corporation, and now in the Ministry of Communications. And every time every phase ended up with a very limited success, and sometimes even in failure. And all the times we face the same challenges. Why? Why there is no interoperability? Why are so many multitude of electronic signatures? Where there is no compatibility? And then, when in the third time this machine was idling in the same direction, we started to think what should be done to avoid this deadlock. And the answer was very simple. Indeed, in order to make interoperability of many complicated information systems, it's necessary to locate one, say, point of assembly for all, and then all information systems should develop a roadmap in order to come to that point of assembly, so to speak. And there was no such point of assembly, neither in 1991, when the first edition of electronic government was made, nor later on, but even now, across the space of the electronic government, there are many projects, but there is no single ideology, a philosophy which is gives a danger to situation. While this point of assembly started to work in border transactions around Russia, a number of formats created, and there that machine was again cloned this approach. There is a CIA, they have certain IT people, they created their own. There is a economic association with the government, with China, there's European Economic Commission, they have their own developers. There is European Asian Economic Society. There is great movement to develop international information system, and the same situation reproduces itself what was in Russia in 90s. Every department tries to develop their own information system and would not want to see what is going around them. In the adjacent department, huge amount of money is spent, and there is no interoperability. And this is from this stems the question which you asked. When we will finally arrive to interoperability? In the international field, there is no decisions which would force us to move to the right direction. That's why when we try to formulate this point of assembly and propose it to the international community, and we started with the CIS countries, we created a certain provocative step, if you will. So we have 11 CIS countries, and the Ministry of Communication is with us to develop a trusted information spot. Okay, let us place the information point of assembly in Russia, and you will adjust to us. You understand what the reply was. Okay, in this case, we took the federal documents, we developed a certain virtual model, we call it this way, and suggested it to CIS countries. They immediately voted for. And now both Russia, Kyrgyzstan, Tajikistan will have to move towards that point of assembly. But if we have developed that, we proposed it to Eurasian Economic Commission, and we were supported. We have voted to the economic cooperation with China. We offered it to the European Asian Economic Commission. We started to fight with the Department of State in United States. And now we're trying to talk to Google, trying to find some common approaches. That's why it's easier to create universally applicable solutions which would enable to adapt Russian reality and reality of other nations to those international norms. And I think this is the only plausible way, because right now to unify the entire Russian space is not possible. There are too many things which have been created over the last 20 years in this area. Have I responded to a question? Thank you. Ivan, I think, wanted to, if I may. Well, I like the question about the various jurisdictions, and I like it because we spoke about the protection of creative work, and indeed we pay a lot of attention to national laws, and we argue a lot how things should be. But in real life, the situation which you described is not an isolated situation. This is a standard situation of pirate network resource. When services are placed in one nation, a domain registered in another jurisdiction, site works on the other, on another third-country language, and this is registered in such a way so that you won't be able to find the say rules. And there are many, many businesses that are kind of across the globe. And when we speak of a situation when we have to protect copyright, that's one of the loopholes which we should understand that it would exist for at least 5, 10 years. We won't be able to address it. How things will develop in the future, it's a different pair of shoes, but so far there is a gap in time which we'll have to bear, and we should not go far. For examples, the largest literary resources are Russian registered in Ecuador, and some other resources are registered elsewhere in exotic nations for us. That's one part of the story, but other side of the story is that the international laws to protect copyright, Geneva Convention, is not a universally adopted document. if we look at that, there are nations who are not signatories to that convention, and indeed there are always opportunities, loopholes. Well, now that we are well, there are some rogue states, using the American terminology. There are nations where they do not have many copyright for things. For that state, it would not be profitable to adhere or to access to international copyright protection conventions, because they will be able to benefit from offering their services to offshore side. We have not even seen a tenth part of the problems which we will be seeing in the future. The discussions which currently going on are indicative of the sector. Over the last 3 months, I've seen 3 or 4 conferences where people try to arrive at certain solution, offer some proposals. It will face great challenges in the next years to come relating to protection of copyright. And indeed, this is a reason why I would like to say the following. Protection is not the only thing that we can do. Indeed, when you think of that, you can say that the issue and the difficulty and the problem which people have with the internet is that, contrary to the industrial, when you have any, say, pre-election campaign, you see the programs of jobs, occupation, economic growth. There are very clear understanding what is good and what is bad, even if it is wrong. But people think they understand what is good and what is wrong. They may err, but they have certain confidence, and people are comfortable. Maybe it works, but they live in the internet. We are limited because we do not have the sense of value of internet. What is good in internet and what is bad in internet. And this is a very discussable area, discussable issue. We are still, making statements. We are speaking very pathetically, trying to substantiate what is good and what is wrong in internet. But here we have a very interesting story related to national jurisdiction. All the international conventions like Berne conventions, and Russia is a part of WTO, very strongly binds and limits people, because it includes the regime of asymmetrical responses, because initially it was very effective when Russian legislation was changed. If there are facts proven of violation of a certain violation of Russian law, there may be an asymmetrical response to that. Other nations with the Russian can start a process of limitation of access to certain markets, which creates real questions and creates a fight of one lobbying group against another lobbying group. In this case, the prevailing overriding value in my mind is that we should understand as a valued expansion of the public domain and be proactive. It's not necessary in the discussion of what should be protected and what, but to liberate, perhaps, make free. And I would like to see that we should continue discussion about values at a later stage, lately. So the sooner we start that, the sooner we'll arrive at certain solution. Thank you for the opportunity to share with you my thoughts. Question to Vitaly. I liked what you said. Ilya Levin from Israel. I like your idea that security, for one hand, human rights, on the other hand, should be addressed in parallel. A balance should be observed. This idea is close to me. But I do have some optimism. I would want to ask you a question. Is this optimism grounded? Because achievements of civilizations, Western civilizations, particular human rights, are very sacred for us, for people who live in the 21st century, and we worship. The security is also a good thing to do after the terrorist act. I think that those things are deeply contradictory. I think the human rights are contradictory to that value with fairness. It's another subject matter. But my question, what should be done? If we say that these two values, security and human rights, are dialectically contradictory, that's fine. But still, Where is the light at the end of the tunnel? How are we going to address this issue? Even a little bit. Thank you. Well, this is an issue which is a more philosophical rather than a legal issue. Speaking about security, the security we need not for abstract purposes, but we need the security to protect our rights, right? Our life, our home, our integrity. There is no freedom without security, because otherwise it would be a naked declaration. But on the other hand, the security without freedom is meaningless, because it will be security which exists in the prison, for example, where you are protected from external factors, but you are not free, you are directed as to what you are supposed to do. They are interconnected, no doubt about that, and indeed, we have, there is some rigid ties between the two notions. We cannot say that we will unlimitedly increase the freedom that will not impact security. When we go past through security check in the airport, our freedom are limited. You agree? But at any rate, we should not look in, while developing a new legislation, to enhance personally one aspect at the expense of another. Sometimes we might slightly tilt the scales, but we should not definitely say that we will be aiming for more security, or we will aiming for more freedom, because that will ruin the other part of the equilibrium. Another question? From Skolkovo. It's a comment. It's not a question, actually. Recently, I attended a conference of the Internet Governance Forum in Russian Internet Governance Forum, where Jeff Moser spoke, who is a key expert on ICANN security issues, who represents this issue of self-regulations. I was very surprised when he said that indeed the private industries were not interested in information technology because this is expenses for them rather than revenues. On the other hand, he said, if I understood him correctly, that he supported actually the idea about the trusted segment of internet, insured internet, which was really a novelty for me. Continuing the issue of security and continuing what I've heard at this roundtable discussion, that we should not try to say aim for big aims in regulations. We should regulate what we understand that, like child pornography or various bad content on the internet. In continuing this, I would like to mention that there is a regional international conference of cyber crime, a European Convention on Cybercrime, dated 2001, which was sent to by many countries. It regulates the content, the criminalization of certain actions, defines the crime, and it contains certain procedural aspects as far as collection of evidence is concerned. But for Information Russian Federation signed that convention initially, and then withdrew from that, withdrew its signature. That's how we stand vis-a-vis that convention as of now. Yes.
Yeah. I'd like to respond to the comment with another comment, basically. And it relates to many of the things that have been talked about here today, and it reflects my thinking about regulation. I think it's very important, before we talk about most various proposals for regulating various parts of the internet, that you be sure there is actually a problem, and not simply a hypothetical problem, a potential problem, a legal theory that there could be a problem, but there actually is a problem. And this is some of my resistance to some of the Web 3.0 proposals, some of my resistance to the unification of electronic signatures, some of my resistance to the jurisdictional problems. I mean, these are all conceptual ideas. Maybe it would be better to have unified signatures, maybe it wouldn't. Jurisdiction, is it a serious problem? Is there a serious problem? If there is, then you may have to do something. But if you're not clear that there is actually an effect or a serious problem of important laws being broken by companies that are located in different jurisdictions, then you don't actually have a problem. And this is a big problem in the United States, as we often have this tendency to react based on some conceptual kind of issue. The fact is, for example, to talk about jurisdiction, the jurisdiction, quote, problem, it's very difficult to build a successful company that's not physically located in the country you're talking about. For example, Google is here in Russia because they want to provide good service. It's very difficult, it's not impossible, very difficult to be a highly profitable company without a local infrastructure. And once there's a local infrastructure, there's jurisdiction. So sometimes the jurisdiction problem solves itself, sometimes there's other ways of solving it. I want to return to what I said earlier. My general instinct, this is a common law bias, is that courts solve these problems better, or anyone solves these problems better on a one-by-one basis. You can talk forever about the difference between freedom and security without getting any answer because it's a philosophical discussion. You can only give a meaningful answer when you have a real case in front of you. No one can answer what's more important, freedom or security, because they're both important. No one's going to say, only freedom's important, only security. It's a ridiculous discussion. You can only answer these questions when you actually have a real case in front of you, and often the answer is then made clear by the facts. So I would recommend, and I'm only an outsider, I don't have it, but before trying to chase conceptual problems, I would suggest that everyone in this room attempt to identify the facts and try to act on actual facts that indicate a real problem.
Dear colleagues, I would like to take part in this discussion of a little bit. I already said in my presentation, when we plan some amendments to the legislation, we need to understand the limitation and what we are based on. As for the internet, I would like to repeat, we have the Russian constitution, we have international agreements like Human Rights Convention, and no of these documents have a contradiction between the freedom and security. We can see this contradiction of these two definitions and certain political steps. Normally the competition between the human rights, freedom and security exist in the political world, not for lawyers. Certainly we have some interesting issues here that can be resolved theoretically, but my response is that there is a real life, there are real relationships that should be described by the lawyers, and the more professional the lawyers do it, the more freedom and security we can have. If there is no freedom, no security can be provided. There are a lot of examples of the countries where there are no political and economical freedoms, and the level of security is also very poor. And I don't really want our country to come to this very negative result in internet regulation, and I always switch our discussion to legal matters, because within our political system the professionalism of judges, lawyers and legislative part are very crucial, because many mistakes come out of non-understanding of people of what they do. There was an example given by Victor when there are different court decisions contradicting with each other because the judges and the lawyers don't really understand the decisions they make. So the question of jurisdiction is also important here. I would like to give you more fact here, because probably few people think about it, because now the ICANN Corporation is deciding on opening new domain zones. It could be hundreds or thousands. We have some generic zones, some country zones, and some international like .rf, and we will get probably thousands of these domain zones. And it also has some technical questions, because in this case the connectivity and routing metrics will be enormous, huge. In this case we need just new computing tools. As for the legal matters, we have a lot of interesting issues. For example, we will get a .google domain, and nobody will doubt that this domain will exist in the United States jurisdiction, and probably exactly in the Californian jurisdiction where the ICANN is registered now. In Russia, we have 3 domains, .ru, .rf, and the old one, .su. And now we've got the information in the media that the request for the domain .moscow and .skolkovo will be satisfied, and the question which jurisdiction will be given to this the .skolkovo domain, they can be also exist in California where the ICANN corporation is incorporated. Because if we use a .moscow domain, that all the personal data will be protected by the American law. The same will also deal with the .skolkovo domain, but the administrator of these domains will be located in Russia physically. And I haven't read any article about with the analysis of this situation also, but the number of problems could be even higher than the disputes about the breach of law in the .ru, .su zones. So there are a lot of interesting questions, issues we need to deal with together. I would like to support Mr. Wu in his idea that we need to resolve real problems and not the hypothetical ones, but I disagree with him that there is a problem with the signature. There is no problem with the digital signature, there is a problem with the service. When I was talking about my colleague when she needed $3,000 to go to Israel, if there was a service of online consulting, it could have cost $300 instead of $3,000. So there's a real problem that we need to resolve, and the digital signature is just a tool for this issue. And what Mr. Yakov was talking about is also one of the components in this area. The activity of the operators providing the service are also one of the aspects. And we also decided the really complicated humanitarian technical systems can exist when all the components are described in 3 dimensions in a legal, organizational and technical ones. But all these lines should be crossed in one dot, because technical, legal or organizational problems, but it is secondary to the real service, because people want to be educated, to get medical care, to travel. What I want to resolve, there is no problem of digital signature. I think it's a secondary problem in reality. More questions? Vladislav Buladov, my questions deals with the digital signature, because in Russia we have some crypto providers. For example, the Crypto Pro company that also worked out a digital signature. There are some American analogs of digital signature, for 128 bits. How do you see the opportunities to find a single platform that should be approved by so-called secret services in all the countries? What can also finance it? What can support the system? I don't want to make a propaganda of it, but if a certain company wants to take part in electronic auction, it has to pay 5,000 or 6,000 rubles a year. But if an individual wants to buy a certain digital signature, and uses digital signature in the network and sign documents on governmental sites have to pay 800 rubles, but how can it exist in the international area? What basis can be used here? As one of the authors said, it is very simple, Dr. Watson. There is the trusted third party technology that is against X842 standard and also allows to recode the signatures made on different algorithms. We implemented in 2006 at ROS Technology. This technology has been working for the last 6 years, and every time we show it is an experiment how it can work. However, another problem is acute. The technology doesn't work without institution. If TTP can be in France, United States, in any country, we have to sign an international agreement about it, and we use such an agreement for the Eurasian Economic Commission, and we sign such TTT agreement. You want to discuss? Do you have a specification in order to deal with American colleagues? If you have such a specification, let's work with American colleagues. We would like to work out a specification, specification for working out international legal acts, a specification for the audit of technical services, a specification for software. I think it's a set of specifications, and all the specifications should be accommodate as common logics. For example, in the APEC states we are currently having the theoretical discussions, but in the Eurasian Economic Commission we do a real job. We have 3 countries. Every country has its own cryptography. Russia is working on GOST, the Belarus uses its own standard, and the Kazakhstan also its own. And we worked for a year on this issue, and the top secret service of all these 3 countries decided to use one single standard. That trust is a political issue. When there is a trust, you have to check every trust anyway. And this mutual mistrust was resolved in the international agreement I mentioned. Now we can rescale it to the United States of America. So we have to reach some legal agreements with the United States, with the European Union. For example, the problem of Web 3.0 is cut with the European Commission, and we also achieved a certain understanding. There is only one option: to agree. In the area of information security, nobody can actually let other country dance as we want, as someone wants. But you said that China support you in the within the APEC. China supported us, but normally we discuss with the State Department of the United States. What was the argument against? What was the problem? Probably the same arguments that you heard today. The first is the danger that Web 3.0 can kill the whole internet, and the correlation is 1 to 1 million in terms of transactions. And the second argument is that there is a lot of now, but we don't need to do anything, but we have a lot of things here, but what is not interoperable. And if we can follow this way, we will have young people actually asking all these questions every year. Why we don't have any interoperability? Because the countries didn't manage to agree. There was also a representative from the Ministry of Justice of Russia. You could also have talked to him. I also wanted to tell you something about the values, and Timothy was absolutely right that we don't need to resolve problems that don't exist. Let's deal with real problems. But this principle should be applied to new applications. When a business comes to a market that with a certain application that is not demanded by the society, it fails, because without profit the company cannot work for a long time, and the government doesn't need any profit. If there is a political will, the government can do everything what it wants. It's an absolutely different way of existence and an absolute different way of achieving the goals. And we, as the so-called shareholder of our governments and our countries, do not want to operate with all the privacy data, and we want to keep this privacy data in the interoperable mode that will be available to the secret services of all the countries. Do we want it or we don't? And this discussion should be made publicly with the participation of everybody, and not in the discussion between the some Russian authorities and the Department of State of the United States of America. And because this is already went ask me and you. We used to think that internet is a very democratic thing with its own values, because internet reflects the values of those people who create the internet, of the pioneers, because the number of pioneers was not significant, and they act within the values they created initially. And as soon as every one of us becomes an internet user, everyone in the user comes with his own values that we want to associate with the internet. And we have to see a social or public value, but this public value is not predictable. If we want to have a positive result of this fight should be open. It shouldn't be a pure technical fight that can be resolved through the international conventions signed by the officials and politicians, and then the newspapers and media can publish it, and then we can know that the secret services of all the countries know everything about everyone. Then that's actually the end. There will be no problem, and we shouldn't create any else. I would certainly support you completely, and my participation in this forum and my open speech to these very sensible problems is approval of it. Within the APEC, we decided to carry out a number of seminars where we can also involve some international associations like ISOC. If you want to involve some other organizations, we currently want to include the W3C. So we're open for any discussions. If these discussions show that the problem doesn't exist, we won't deal with it anymore. So we won't see any efforts to take everything under control. You say that business doesn't want it, and who is caring about the health of my colleague who didn't get the service she wanted? If we keep staying in this mode, I think it is not really profitable, because the service can be beneficial for the whole society, because we can be in a situation where we need some medical okay, let's discuss different shapes, let's invent something, we have material, these materials are in the site, in Russian and English, let's talk. And our proposal for Skolkovo and Google is the invitation for an open discussion of all these issues. Please identify all the critical points of our conception when we can discuss and or correct it. What would say an advisor of political issues?
Well, we give the floor to Patrick Ryan, and then we'll have a question from IBM representative, and then we'll wind up. Спасибо.
Address that particular issue that Alexei brought up. I believe that that's the most important thing. The community, I'll tell you, speaking to various different groups about the Web 3.0, is very concerned. And they're not concerned about anything that you're saying here today. The concern is the lack of information about it, and it's just generally that there's a proposal from government. And the internet community is naturally just concerned about proposals that originate from government. But to the extent that you're here today speaking to everybody about this openly, that's an extremely positive thing. And bringing this proposal to the community where it can be discussed with civil society, groups like ISOC, groups like W3C and others, there's a lot of opportunity, I think, there for this to really get discussed and potentially get some traction. So, thank you for speaking openly about it.
I wanted to make a comment about something the gentleman from Google said earlier, and then use it as the basis for a question. In his last comment, he actually came back close to the question I have, but not quite there. And it's a practical question. It's not a legal question. Earlier in his opening remarks, he asked people if they had called the police when they had been the victim of a cybercrime. And very few people said yes. And the implication from that, and from the way that the question was phrased, is that to some extent, the problem of cybercrime is one of the user's lack of bringing the crime forward, which immediately struck me as incorrect. I don't think the problem is that. I think, at least in the United States, most people know that their local police force is not equipped to deal with the issue of cybercrime. They know that because their neighbors or their friends have reported crimes and nothing has happened. They know that because they see reports on television, on the news, that there is nothing the local police force is able to do. And so they simply don't report it. Or if there is a company that is logically connected to the cybercrime, for example, it's a phishing expedition that relates to a particular banking institution, one might report it to the bank and see if the bank knows about it, which I have done many times, and the bank almost never knows anything about it other than to say, we didn't do it. But I think the reason for this problem is the nature of the internet. When one used to try to use the telephone, or as you said, snail mail, to commit crimes, it was a one-on-one crime. And the internet, of course, is one-to-many. With a single click, one can send out notices to thousands or millions of people one would like to scam and take advantage of. So it seems to me that if we want to help or have the public bring more of these kinds of problems forward so that they can be solved, one of the things we have to do is a better job of enabling the ordinary citizen to know that they're solvable and where to go to get them solved. At least in the United States, I have no idea where I can go to get that help. So my question would then be, on a practical level, have we done enough to make cybercrime transparent enough, and the fact that it sometimes can be resolved or solved transparent enough, and are there downsides to doing so?
I think you've stated it very well. Both the problem and the solution in many ways. This is This is an area that that requires a lot of collaboration and a lot of education. I certainly did not mean to imply, and I could see how this could be read that way, but I did not mean to imply that, you know, there's a blame the victim in this story, right? That people should be going to the police, and because they don't, it's their fault. That is certainly not my message at all. Only to emphasize exactly what you said, that there is a lot of uncertainty around how to fix the problems. But there's a tendency to, at least in the regulatory world, and this is something that's happening on a global scale, we're seeing lots of proposals for new laws to fix these problems. And I would suggest that passing new laws isn't going to necessarily deter the crime itself. We need to look at other ways to fix cybercrime, and that does involve further education. It involves greater engagement by companies like Google and by other companies that are part of the internet ecosystem in order to be sure that there are methods and that users know how to redress their problems and that they can also facilitate those solutions.
Спасибо большое. Думаю, мы на этом закончим.
Well, I think we will wind up. I think that this discussion was interesting. And of course, do not forget to pick up materials about Skolkovo.